We're here today to talk about eviction nuts and bolts. So we're going to take what I do for lawyers as a 7-hour seminar, and we're going to condense it down into about an hour. So this is going to be the Cliff Notes version of the eviction process. Some things might seem a little confusing because we've cut out sort of step one of the eviction process, which is sending termination notices. I did a whole seminar on termination notices the last time we did these series, and that's available on the Vermont Landlords Association YouTube channel. So maybe go check that one out if something doesn't quite make sense or you're a little confused. So what this one is going to do is going to start us right at the court process. So the court process is step 2 in an eviction. So after you've sent a termination notice to your tenant, and the tenant either hasn't paid the rent or hasn't corrected the behavior and hasn't moved, what do you do now? What are your options? All notices lead to court. It doesn't matter what the reason is you want your tenant to go. If they don't go, the only way to enforce that is by filing an eviction action with the civil court. You're basically suing somebody to get your property back. That's really the nuts and bolts of what it is. That's it, done? Okay, no. So a little point of clarification, we have a lot of different rules that govern this process. We have court procedure, which is specific to Vermont. We have eviction laws, we have landlord-tenant laws, we have habitability laws, we have federal Fair Debt Collection Practices Act laws. That's where this third bullet point comes into play. We always file eviction cases in the county in which the property is located. So if you happen to be a landlord in Bennington and you own property in Burlington, I'm sorry, you are going to have to drive to Burlington for your eviction case because we can't file it in Bennington. So Vermont's court systems are broken up into 14 different counties, and each county has a civil court, and that's where the cases are brought, depending on where the property is. For here in Chittenden County, that's in Burlington, right on Main Street, across the street from Nectar's. Seems to be, it's not the one on Cherry Street. They do other types of law there. So a lot of tenants go to the Cherry Street court when we have evictions. Tells you maybe what you need to know about the tenant. All right, so some helpful definitions, because you know us lawyers, we like to have a lot of fancy words for things. So plaintiff's the person who brings the case. That is generally the landlord. Sometimes it could be the tenant. I do have landlords who get sued by tenants for various reasons. It's not as common, but occasionally. Defendant, so that's the person who's being sued. Usually the tenant in an eviction case. But again, sometimes it could be somebody else. So you'll hear people talk about a summons. Summons and complaint. You need a summons and complaint. What are those? So a summons is the actual legal document that tells the tenant they're being sued and tells them that they have certain things that they need to do, like respond to that paperwork. Complaint. This is another legal document. This is a document that sort of lays out the story. What's the problem? Who the parties are, where the property's located, what are the issues? If they owe rent, how much rent's owed, if there's other issues, that's where that goes. The complaint is what puts everybody on notice what the landlord's looking for in terms of money, possession, other claims. Is there damage to the property, unpaid utilities, that type of thing. Well, because we have to have lots of definitions here, right? An affidavit. Sometimes you'll be asked to sign an affidavit for court. This is you attesting to that certain things are true. It's almost always notarized. Actually, I can't think of a time when an affidavit is not notarized. And it's just providing the court with additional information sort of under oath. Motion. Motion's something that you file with the court asking the court to do something. Courts don't take any action on cases unless you've asked them to do so. You could literally just file a case with the court and it would sit there till some clerk was like, wait, nothing's happened on this. And then they might send you a letter saying nothing's happened, we're going to dismiss your case. But generally, if you want the court to do something, you have to ask them to do it. Writ of possession. This is the really important document in an eviction. This is the document that gives the sheriff the legal authority to come remove somebody from your property. That's our gold standard right now. That right there, that's what we're looking for when we start an eviction. Because that's what's going to get you your property back. And the one that we hear talked about sometimes, merits hearing, damages hearing, final hearing. This is, depending on how the case goes, when you would go in and you put on all of your evidence about who you are, what is owed to you, and ultimately the court makes a decision about who wins. Most of the time it is the landlord, because by the time we've gotten to this point, the landlord's documents are usually in pretty good order. So we know most of the time that we're going to walk out with what we're asking for. Every once in a while, doesn't happen, or sometimes we ask for things just to see. You got to push the limits sometimes. So, but that's what that is. All right, court process. So the bad news about evictions in Vermont is that they are treated like any other civil action in the state of Vermont. So they're handled for the most part exactly the same as personal injury cases, medical malpractice cases, giant breach of contract cases. And so you're stuck sort of in this same process. I will say, for the most part, the courts sort of fast track eviction cases so they don't let them linger. They're generally motivated. They have them tickled internally to have hearings scheduled or status conferences scheduled because they are looking to wrap most evictions up in 6 months or less. Yes, you heard that correctly, 6 months or less. And that is fast for a civil case. Yep. Anybody who's been through an eviction in this room can attest. 6 months or less, that's about average. So our eviction process is started by filing that complaint with the court. That's how you start it. And paying the court the filing fee. As of today's seminar, that filing fee is $295. I put the date in there because the court changes it from time to time, and I figure if somebody a couple years from now watches this, they would probably get really mad if they went to court, and now the filing fee is $350. So anyway, $295 right now. The thing that can mess folks up, if they're not familiar with the eviction process, is that a copy of your lease and a copy of your termination notice have to be attached to the complaint when you file it with the court. So what happens if you can't find your lease? You should probably call a lawyer. We need to chat. We might have some problems. But make sure you keep your documents in order, right? Leases are important. Your termination notice is important. If you send the send the tenant a termination notice, please keep a copy for yourself. We need it. If you don't keep a copy, you're going to have to resend it again because we need that copy to attach to the complaint.
Can you attach the fees related to this whole process onto the tenant you're trying to evict?
Yes. So under statute, filing fees and sheriff's fees automatically you can attach to what's owed. If your lease allows you to collect attorney's fees, those can also be added to what's owed. I'm here to break the bad news to you that you can get a judgment order that all of those things are owed to you. The chances of you ever seeing a penny of that money are very slim. So yes, you can get a judgment order that says it's all owed to you, but
so it's not really enforceable.
Well, we could do a whole seminar on collection, and it's a whole separate process with a lot of other issues. And part of the problem is that most of these cases that we're talking about for evictions are for non-payment of rent.
How do you expect to get their back rent then?
Right, you won't.
You won't even,
You're not going to.
can't even guarantee that.
You're not going to.
It's just down.
Right. So part of what this seminar is about is to impress upon you the importance of taking action quickly, particularly in a non-paying rent situation, because you are looking at a long road and very little chance of ever recouping that money. It's gone. It's most of the time people are not paying the rent because they don't have the money. It's not because they're stashing it somewhere. I mean, maybe they're using it for other things they shouldn't, but they don't have it. And that's why it's not getting paid. So a little caveat, I know some folks like to represent themselves, and it's okay. Our system does allow people to represent themselves in court. But that summons, remember that summons document that I was talking about? You have to be a licensed attorney to sign a summons. Or if you're representing yourself, you have to take it to court and have the clerk sign it for you. So you as a non-attorney can't sign a summons. I've seen some people try and it gets your case dismissed. So don't do it. Oh, everything that you do wrong in eviction has the potential to get your case dismissed. That's the other bad news for landlords. It's one of the few types of civil process where one little misstep causes the consequence of your case being dismissed. In almost any other type of civil case, if you didn't quite do something right, the law allows you and the courts allow you to fix that. For whatever reason in this area, if you haven't done something exactly right, 9 times out of 10, the court's just gonna kick your case out and make you refile to fix it. Yeah, I know, right? Super fun. So Sarah, I think everybody's gonna wanna list their rental properties after this. So the good news is if your tenant owes rent, right, we needed to have an upside here. If there's rent owed, you can ask for what's called a rent escrow hearing as a part of the process. You can actually ask for that at any time during the case. I have had cases where when we started it, the tenant didn't owe any rent and they got served by the sheriff and they stopped paying rent. So then we turned around and asked for this hearing. But most of the time when you're filing an eviction, the tenant owes you money. So you are going to request that, again, by filing that motion and that affidavit, right? So you're asking the court, I want this hearing, I want this process, please set this for a hearing. Then we take all of our documents after we file them, we send them to the sheriff's office for service. So the sheriff gets to serve all of the civil process in the state. Chittenden County Sheriff's Office is super busy all the time. I believe the most recent filing number I got from the court, we were already up to like 1,000 cases already for 2020. And so all of those get served by the sheriff.
1,000 cases?
Civil cases.
Oh, just
Civil.
so
But most of the cases filed in civil court, substantial majority of them are evictions.
Could you just take a second and explain what the rent escrow?
We're going to cover it in more detail in a few more slides.
Okay, thank you.
Yep. Yep. All right, so everything goes to the sheriff. Sheriff is very good at his job. He's very good at finding people. He's very good at getting people to open the door. If he can't, we have ways to get them the paperwork legally. Just takes time, right? Everything in the process takes time. Hence that 6 months-ish kind of thing. So once the defendant is served with this court paperwork, they have 21 days to respond. That's where this sort of standard case is treated like every other case in civil court comes in. So anytime you're sued, you have 21 days to respond. So do these tenants. Do most of them file written answers? No. Because, I don't know, I guess the paperwork's confusing. But sometimes they do, and sometimes we have some surprises. The answer is when you as the landlord may for the first time find out that there is something massively wrong with your property that either has not been reported or maybe is not accurately reported. So it's one of those sort of intersections where if the tenant's going to make complaints about the condition of the property, we will see it at this point. Again, process, lawyers, we like rules and dates and deadlines and time frames. So if you've requested a rent escrow hearing, one little quirk there is a tenant has to be served 14 days before that hearing happens. So sometimes if we're having trouble getting them served, or depending on when the court scheduled it for a hearing, we can be on a really tight turnaround. These types of eviction cases are all scheduled together every other Tuesday morning in Burlington. So if we miss one rent escrow, it could be 2 or 4 or 6 weeks before we can get into the next block that's open. So timing Timing can sometimes be tough, and sometimes just that timing scheduling pushes cases out further. Meanwhile, right, you're paying all the bills on the property, you're not having rent come in. Like, this is, particularly when rent's an issue, incredibly important to act right away. I know lots of landlords want to give people some time and not send them notices immediately, but the process you have to go through to get them out if they don't make that rent payment is so protracted that it's not in your interest to wait. Okay, so when we go through this court process, we're going to get you two things: possession of that rental unit through that writ of possession, and a judgment order for money, which sometimes we get, sometimes we don't. Sometimes it doesn't make sense to get it. Sometimes the landlord doesn't want it if we've gotten the person out. But we can get you that judgment order. I have a whole drawer full of them that landlords will never see a dime of. Hundreds of thousands. I should add it up at some point and just figure out how much money is being lost. That's what it is. It's lost. You know, folks scratch their heads and say, we don't understand why are rents so high in Vermont. This is part of the problem. Because landlords will recapture this in another way. Higher rents, less likely to take a chance on somebody that maybe has some marginal rental history or marginal income. This is part of what's driving that.
Do you have any data as far as defaults, people not paying the rent? Is that on an uptick, looking at the economy the way it is, Vermont's economy? Is it getting bleaker?
So what I've seen is not necessarily an uptick in the number of evictions, but I've seen an uptick in the number of tenants who are fighting harder to prolong the eviction process. So it stayed pretty steady in terms of numbers, but they're taking more actions to cause us to have to go to a final hearing or to have to spend more time avoiding service by the sheriff. You know, there's things that they can do. Sheriff can't make them open the door. So I've seen more of that, which is frustrating because it turns the process into a game. It shouldn't be a game. You pay your bills, nobody's going to bother you. You don't pay your bills, landlord's going to ask you to leave.
Back rent can also be wiped out in bankruptcy.
It can, yes.
2 seconds.
Yep. I see less of those. So the question was about bankruptcy, that back rent and other debts can get wiped out in bankruptcy. I see less of those since the last revision of the bankruptcy code. So it's harder for people to file for bankruptcy now. And when that happened, we saw less.
How recent has that?
It's been, I want to say 7 or 8 years. Yeah. But prior to that, yes, yeah. But it's always a possibility. Rent escrow hearing. So back to this rent escrow hearing. So this is if the tenant owes rent. Sometimes it makes sense to not ask for this hearing. Most of the time we do it because it gets you into court. And it actually gets you into court a lot faster than if you don't do this hearing. So what do you have to show if you're asking for this hearing? You have to show how much the rent is. You have to show when the rent is paid. I mean, this all seems pretty basic, right, that you would find this in your lease, but you'd be surprised. Whether or not there is back rent owed. So, and some of this is where it gets a little bit tricky. Our current presiding judge in Chittenden Civil says that if a tenant has made a payment in the month that the rent escrow hearing is happening, she won't issue a rent escrow order because she views the rent for that month as being paid and current. I know, right? Yeah. We still ask for these hearings. We still go to them even if we have those payments because a lot of times we can get agreements out of the tenant for something different. Sometimes resolving the case in its entirety, sometimes a rent escrow order going forward, sometimes for the entire rent escrow. But she won't unilaterally issue it if there's been any recent payments. So, yeah, I know, fun stuff. Let's David, and then we'll come over here.
Is that paying the full amount of rent or considering partial payment?
I've seen her do it with a partial.
Right, so they'll progressively get behind,
Mhm.
and sale won't go to them.
hmm It's just, so it's not that the case goes away or that you can't then evict them. She just won't issue that interim order in the meantime. So yeah, that's one of her quirks. Other judges are different. So you had a question?
Same question.
Okay. All right. Some judges, not this particular one, but in other counties, require that you put on evidence about your termination notice, and they make sure you have a valid termination notice before they will issue a rent escrow order. So they basically do a little mini merits on whether you have all of your proper documentation and proper right to be in court. And some of them will do this even if we don't have a defendant at court with us. So if, for those of you that I see a lot of familiar faces in the room, for those of you that have worked with me in the past, or if you have not worked with me, this is why we go over your notice with a fine-tooth comb, why we ask you a ton of questions about your notice, and make sure that everything is exactly perfect because of this issue. Judges just unilaterally taking up issues on their own. I can't think of any other type of case where this happens. In most other cases, it's left to a party to raise issues of this nature. Erica.
How is that even allowed?
It's this little thing called judicial discretion. Yep. I think part of it has to do with the nature of this type of case, right? We are essentially asking the court to issue orders to remove somebody from their housing, a lot of times to make them homeless, because they don't always have another place to go. And so there seems to be a higher level of care and a higher standard. We're seeing some of these same changes have been happening over in the foreclosure realm as well. That's another area of the law that's becoming incredibly technical, and if you don't do everything right, things get booted out, because again, it's removing people from housing. But this one, for some reason, I think part of it is you see the overwhelming majority of landlords coming to court with attorneys, and the overwhelming majority of tenants coming to court representing themselves. And so the system sees that as an imbalance right out of the gate.
I don't want to ask too many questions out of turn. I just think, I only own my property that I live in, and if it means I lose my house because they don't pay, are the judges at least weighing the different sides before they're making decisions like that?
Sometimes, but if you have a bad termination notice, that's not going to save your case. Yeah.
Can you define a bad termination notice?
One that doesn't comply with the law. I'm going to redirect you to our seminar that we did on termination notices. We spent a whole hour talking about them. There are a lot of things that go into them. Language that needs to be very specific, time frames that need to be followed, and proof of delivery. And if any of those things aren't complied with, the notice isn't considered good. And the court has said through a series of cases that if they don't have a valid notice, they don't have the jurisdiction to hear the case.
You said that in most cases you do this, but there are some cases you wouldn't.
Mm-hmm.
When would be an example of you wouldn't do that?
So if through conversations with a landlord, we think just having them served with the court paperwork is going to be enough to sort of get them out the door, we might just do that first and see what they do. Sometimes if we have something like just a no-cause notice where we're looking for possession and rent isn't owed or isn't a priority for landlord, we might try that first. So yeah, it's usually a situation where there's not rent owed. Okay, so once we got all those, the court can issue our rent escrow order. So rent escrow order is only for actually a portion of the rent that's owed. So our law or statute that governs this piece of process says landlord's entitled to rent from the date the case was filed going forward. So doesn't mean that the tenant doesn't owe the rest of it. It just means that's when the calculation starts for what they have to pay into court. And the reason why we pursue this order and pursue this path on the eviction is that if the tenant doesn't make a payment under that order, the court issues a writ of possession. So it's a track to possession, and it's generally a faster track to possession. So it's sort of remember the earlier comments, if people aren't paying the rent, it's probably because they don't have the money. So we ask for this hearing and we ask for this order with the understanding that probably a substantial majority of the time they are not going to be able to make that payment. And we're going to get the landlord possession under this order.
Conceivably a fairly powerful order. I mean,
It is. Yes. Oh, and is it on this slide or the next one? It's a 7-day writ. So I say it's short. I have a skewed perception of what's short. 7 days is very short for a writ of possession.
So would you recommend that a landlord issue a termination notice as soon as a week after the rent is due?
Yes.
Yeah.
Yeah. So a termination notice can always be cured
yes.
for non-payment of rent. So by sending out that notice as soon as the rent's delinquent, you haven't lost anything. The tenant pays within that time frame. It's like the notice was never sent. But you can't start this court case until that notice goes.
Yeah, that's valid for 60 days.
Right.
And
Right.
we can get them to pay. We've done it and it has
Right.
made
Right.
a big difference.
Yeah. And you are going to have some tenants, particularly if you have like a year's lease or something, where you might actually be sending them a termination notice every single month for non-payment of rent.
We did it for a year.
Right. And then what
So every
happens
time
when
on the 7th day,
Yep.
the last day of this.
what happens when you get to the end of the year? Those are the folks that get those no-cause notices and are asked to move on because the landlord has grown weary of chasing them for the rent.
What if you have a situation where the tenants have disappeared?
Yeah.
I've actually got one that I want to talk to you more in depth about.
We should talk about it later. Disappeared as in like alien abduction disappearance or
Okay, so I'll tell you about it now. We closed on the property January 30th.
Yep.
We got back from vacation January 19th. At some point before January 19th, they left. Their
Okay.
car is still there.
Okay.
All of their possessions are still there. I actually had the police do a
Welfare check.
welfare check last week.
Okay.
And I've known these people. I've known this property for 2.5 years. They've been wonderful tenants up until then, with different landlords. However,
Yep.
they don't know that we purchased the property.
Right.
And they have not paid rent for February, and they're not there. Their car is, but they are not.
We should probably chat, but it sounds like that might be what's called an abandonment of the unit, and there's some strict criteria for meeting that, and you have some recourse that does not involve court action, so let's chat after
Okay.
and go through it a little bit more. Because the 2 times when landlords have the highest liability in landlord-tenant cases is when they're changing the locks and when they're touching tenants' personal property. So you would be potentially doing both of those, so let's chat. All right, how much rent is the defendant going to have to pay under the order? Not all the back rent, but it probably could be a pretty good chunk, right? I mean, most of the time, by the time we file the case, we have the hearing scheduled. We probably are a good at least 6 weeks into the case. So there's probably going to be somewhere between a month and 2 months worth of rent that are going to have to pay into court. But then we get into the fun times with that judicial discretion thing, where the court always has the discretion to order a lesser amount, different type of payment, only future payments. Nothing aggravates landlords more than walking in for a rent escrow hearing and having the judge immediately turn to the defendant and say, when do you think you can pay this? And it happens regularly, right? Because a judge doesn't want to set them up to fail. My job is to set them up to fail. That's horrible, and that's going to be out in the public forever. But my job is to look out for the landlord. So I'm trying to get a payment as big as possible, as soon as possible, because I want the landlord to get possession back. And on the off chance the tenant makes the payment, that means there's some money in the court for the landlord to offset what's owed. So those are my goals, but they don't always line up with what the court wants to do. And the court can reduce the amount of payment or say that there's no payment due if there's a credible habitability issue at the property. So, these are all things we're juggling at this rent escrow hearing, with probably about 20 other cases scheduled for the morning, with lots of, landlords and tenants and the court trying to get hearings through. And so it can be, a real sort of trial by fire for landlords sometimes, trying to do this. But I think in the end, given the consequence of not making the payment, this process is worth it. So to also back up, why would we not ask for this type of rent escrow hearing? Sometimes if I know going in, we are going to have a huge battle over the condition of a property, I maybe don't want to do it at a rent escrow hearing. I want to make the tenant answer my paperwork so they're stuck with whatever they put in the paperwork, and I want to do it at a final hearing when I can be well prepared. So, sometimes there can be other reasons why we wouldn't ask for it right away. I don't always know that sometimes up front. Sometimes we find out about it when the tenant files the answer or shows up at the rent escrow hearing and everybody's hearing about stuff for the first time. Okay, so this is a big one. What happens if the tenant doesn't show up at the hearing? This is not criminal court. If the tenant doesn't show up, we just proceed without them, which generally means we get the order that we're asking for because nobody's there to contest it, which is good. But then we got to have it served by the sheriff. Super fun. Issue, I think this is an issue. It's probably not really an issue. The tenant paid. I actually get those calls sometimes. You're all excited. You email the landlord like, oh, your tenant paid under the rent escrow order. And the landlord's like, what? No! You're like, no, good. You've got money there. We'll just go to step 2, which is getting them out with a final hearing. And generally the court holds that money. We can sometimes make agreements for the court to release it, but then I've got to keep reminding the court to release it, and sometimes that's a slow process. But generally they hold it till the end of the case. Tenant doesn't pay under the order. We have to, at that point, file a motion, an affidavit with the court, right? We're asking the court to take some action. Tenant has not complied with the order. Please give us possession. And most of the time, I always say most of the time, it's a lawyer thing. We don't really work in absolutes. It's just too many weird things have happened. So generally the court issues a writ of possession, and it's the 7-day writ of possession, and the sheriff has to serve it on them first. So you see all these points in time where we can have these delays, which is why this process gets protracted. And then the sheriff in this county is very good. So usually we are doing lockouts 7 days later. In other counties, they only do lockouts on certain days of the week. And so if you kind of miss your window, you're bumped out even further. But Chittenden County is really pretty good.
What happens if it's in the middle of the winter?
Doesn't matter.
That can still be...
Absolutely. We have no restrictions on winter evictions in the state.
Oh.
None. So, totally fine.
Does the sheriff have to do the lockout, or can you do it?
The sheriff is the only person that can physically remove that person from the property. So, if you go to the property and the tenant's moved or gone, you don't need the sheriff there, but it's always better to have them there.
They usually call it. What about
Yeah.
What about all the contents that are in the unit?
So the good news is, I think I have a slide on this later. We've had some legislative changes, so now you don't have to store their stuff. Super exciting. Yeah.
2 weeks, right? 2 weeks.
Yeah, it's 2 weeks from service.
Right.
Yeah. Yep.
Is it still 2 weeks?
Yeah. So judgment order. So this is the other place. So they pay rent into court, or we don't do a rent escrow order. They file an answer with the court. We have to, how do we then get the court to do what we want, which is issue a writ of possession? We may have to go have a final hearing. This is where you get to go sit in the fancy chair next to the judge and answer questions about the rental property. So things like what the lease is, what the agreement is, go through the notice, how much rent's owed, how much other things are owed. Is there damage to the property? Sometimes we may not know the answer to that if they're still living there. But we can get judgment orders. We can get judgment orders 3 ways. Judgment by default, judgment by agreement, or judgment after court hearing. Judgment by default. This is one where the tenant just hasn't responded to any of our court paperwork. So you can actually win that way. You can get a judgment order and a writ of possession that way. And again, look, we file a motion, affidavit, right? We're asking the court, look, they haven't done what they're supposed to. They haven't answered our court paperwork. Court, take some action for us. Give us a judgment order. Judgment by agreement. You might be surprised how often this happens. How many times we can go to court, a lot of times at that rent escrow hearing, and work out a judgment order and possession. Or sometimes, for people who have heard this sort of seminar or, the bad news about actually collecting the back rent, sometimes we're just trying to get an agreement for possession as quick as possible.
How often is the agreement honored by the tenant? You come to an agreement, he owes you $2,000 back rent.
Yep.
You say, tell you what, $500, you get out and you give me the apartment. How often is that honored?
Well, if you're using me, I don't draft documents that don't come with a writ of possession. So when the tenant doesn't move, I can send the sheriff over there to remove him from the property. If we're doing an agreement for possession, it's always going to be written in a way that we get a writ of possession to enforce it. But if you don't put that in there, then yeah, you could make the agreement and they could knock it out. So I should probably add that to my slide. All agreements come with a writ of possession. So this is what's called a stipulation or a stipulated judgment, and that just means the parties have agreed.
Angela, just to drive that point home, if you make an agreement that doesn't have a writ at an rent escrow hearing, is the case dismissed at that point?
You mean an agreement for a judgment or for an agreement on the rent escrow order?
An agreement for a judgment. Using that scenario, they owe $2,000, here's $500, and I'll be out in a week.
Yep.
Make that agreement without a writ, does the case go away?
Depends on what else that agreement says. Maybe. Sometimes.
Hammering the point, don't make it without a writ.
Don't make it without a writ. Yeah. Don't make it without a writ unless you actually want the person to stay there. I mean, sometimes there's a reason for that. We run across these, people make different decisions all the time. But if you're making an agreement that involves you getting possession back, it needs to come with a writ of possession. It's the only way to enforce your agreement. We can get a judgment and sometimes a writ if we need to, if the tenant's still living there after this damages hearing. Final hearing on the merits, that's the big one. Ideally, we'd like to do this one after the tenant's out to collect all those damages or having disposed their things that have been left behind, or those unpaid electric bills that you found out about after they left. But sometimes we don't have that luxury, and this is the only way that we can get the tenant out. Court takes testimony. You need your invoices, you need your receipts, you need proof of damages. So record keeping is pretty important. Pictures are also great. This particular judge loves pictures. The more pictures you can show her about how horrible this place looked, the more likely she is to just award you what your damages are.
You also recommend pictures of repairs? Like, I have a friend who was dealing with a situation, they kept breaking the light globes. Say, well, that's why. Don't fix them, they break them again. So finally, they just videotape them.
Yep. I mean, I would say you should be taking all kinds of pictures at the time of move-in so you can document the condition. And then if you're running into those issues where they're breaking stuff and you're fixing it and they're breaking it and you're fixing it, because that just provides that documentation that, look, I was there on Friday and the globe was up, and now it's Monday and the globe is broken.
Can you also, after having a discussion with your tenant, say if this keeps happening, then you're going to end up paying for all the money that goes into repairing this?
You can. Yep. I mean, if they're breaking it, you can charge them for it anyway. You can deduct it from the deposit. But the challenge is always getting actual money out of folks. I mean, you can bill them for all kinds of things. Not that I want to put anybody on the spot. How many of you have a judgment order against a tenant for anything in this room? How many of you? It does anything. How many of you have gotten paid on that judgment order? I got a couple. They're the exceptions. Most landlords never see a dime, even if the lease says that they're responsible for it. Because the system is set up for you to collect money from people, and if they don't have the money, there's nothing there to collect.
But I have a good attorney.
But as long as you state that very clearly in your lease, that if X, Y, and Z happens,
Yep.
then that will be subtracted from the amount of your lease upon moving out.
Right, deposit,
That's
yeah.
totally legal,
Yeah,
right?
damage like that can always be deducted from the deposit. Yep. Of course, if they haven't paid a couple months worth of rent, your deposit probably has been eaten up anyway.
A few minutes ago, you mentioned unpaid electric bills.
Yeah.
If you evict a tenant and there are gas bills, electric bills, whatever, does that become the landlord's responsibility, or
In
they collect?
no, in Burlington, as long as it's not in your name.
Okay.
In Burlington, you're off the hook. Burlington is the only municipal electric company that does not lien the property for unpaid electric bills. I know everybody likes to complain about Burlington. You have one thing over everyone else who has municipal electric companies. In other places like Swanton, Morrisville, where there are municipal electric companies, if your tenant doesn't pay an electric bill, the municipality has the right to lien your property for their bill. Burlington doesn't do that. It's the only one. So no, unless the account is in your name, you are not responsible for it. Yep. Writs of possession. So we have two writs. We have a non-escrow writ, right? So they haven't paid rent into court, and we get a writ that's a 7-day writ. Every other type of writ, so the ones that come with judgment orders, are 14-day writs. So that means 14 days from when the sheriff serves them with the paperwork. Yeah, must be served on the defendant. The nice thing in this county is that if the defendant shows up to court and we get a writ of possession, I can, or whoever your attorney is, or you can, have them sign what's called an acceptance of service, which says, I got a copy of this and I don't need any other type of service, and the sheriff here will enforce that. So they don't need to come out and serve it first. There are some other counties which shall remain nameless that is not the standard. So, again, things can go more smoothly if people show up. If they don't show up, we can still make it happen, but everything, for the most part, has to get served by the sheriff. The defendant doesn't leave. What happens if they don't leave? That's why we have the sheriff. That's why we have the writ of possession. The sheriff can legally put hands on that person and physically remove them from the property while you're there changing the locks. I always people like the really fun cases. We had one where the tenant got drug out in handcuffs because they weren't going to leave. They were resisting arrest. There were some criminal charges that came with that one as well for that behavior. But that's why we have the sheriff there, because they have the ability to do that. We had one where I think the tenant maybe punched one of the officers. So it can get a little rowdy. We don't want you guys to have to do that. That's for the sheriff. They get paid to do that. They're trained. They have the gun and the badge. And they are happy to do it. They're very happy to do it. But what do you need to do when you go there? You have to be prepared to change the locks. So whether that's a replacement lock set, whether you come with your locksmith to rekey, but be prepared to secure that property so the tenant can't get back in.
What happens is there ever tenants that, break back in or whatever because their stuff is still in there?
No, that never happens.
At that point, it just become a trespass? And
At that point, it can become a trespass. Yep. But I would say the sheriff's usually pretty good if the tenant's there at the lockout of reading them the riot act about you're not allowed back on here. Sometimes we have a few days holdover from when they need to come remove all their stuff, but what we've been finding is that most of the time now the tenants are getting their property out of the unit during this time frame because they know that it's going to get thrown away at the end if they don't. Possessions restored. So, yeah, we've been talking about tenants' personal property. What do we do with it? New statute went in probably 3 years ago. Now I kind of lose track of time. It all sorts of blends together. You can dispose of property at the end of an eviction. Yay! You used to have to store it for 60 days. It was a nightmare. Can you imagine the phone calls with the landlord? Like, yep, you just got possession of your property. Oh, the tenant left all this stuff there. Yeah, you're probably going to want to store that for 60 more days. Yeah, people were not happy. Not happy. So 15 days from when the sheriff or the tenant has accepted service of that writ of possession and the landlord being restored to possession, you can just dispose of everything. So there's no storage obligations beyond that 15 days.
This whole process of the eviction process.
Yeah.
And if you're worried about your property, can you have somebody go in to check it and give the 48-hour
Yep.
notice and
Yep.
have people just go in and check it?
Yep. You can always access your property with a caveat that sometimes it doesn't make sense. Sometimes we have situations where the relationship is so volatile, I don't want the landlord there because I don't need them being charged criminally or having some other sort of issue. But relationships can't break down that much. But landlord always has the right to access their property in 3 circumstances. 1, on 48 hours notice between 9 a.m. and 9 p.m. And that's with or without the tenant's consent. You send that 48-hour notice, the tenant does not need to consent to your entry. You have the right to go in. Now, if they're standing in the door saying you can't come in, like, don't, push them or go in. The second is with the tenant's consent. The statute actually says, with the tenant's consent, which shall not be unreasonably withheld. Like, that second part there always kind of gets forgotten about. So that's sort of the stop and knock, right? You're looking for rent, or I say that one qualifies most of the time. If the tenant calls you up and says, hey, there's a problem, can you come fix this? And you're like, great, I can be right over. You go over and knock on the door and say, I'm here to fix the problem, and the tenant's like, you need 48 hours notice. Like, ugh, what, really? Clearly wasn't that big of a problem. So tenant's consent. The third one is in the case of an emergency. In an emergency, you can go in without notice or without consent. And there's some more of that section that says if you have an imminent belief or reasonable belief that there's imminent harm to person or property. So that would be things like a welfare check. That would be things like windows open in the middle of the winter. That would be everybody's favorite running water. Right, Monica? Everybody's favorite, running water. Right, Adam? Sorry, I've got our Puriclean and our insurance agent over here. So, sitting on opposite sides of the room. Running water, right? Running water that's not a shower, broken pipe, something, running toilet can cause a huge amount of damage. So that's sort of our catch-all. We can make it fit a lot of circumstances.
Can that be included in the lease? The tenant agrees that upon proper notice?
It's in state
I
statute.
understand,
Yeah, you can absolutely put it in your
just
lease.
to make it clear before
Yep.
they move in, so.
Yep, you can absolutely.
Easier sailing if you do something like that.
So the one slide here I forgot as I'm going through here and realized the 14-day window for your security deposit return starts from the time you take possession of the unit, even if you're in the middle of an eviction. So make sure whenever you are taking possession of the unit back that you are calendaring the starting of that 14-day window to get that letter out to the tenants, right? Because that's another one of those, like, you miss that 14 days, what happens? Like, it's a mess.
So, going back to what you're saying, so like we had an incident of where there was a surge in electricity over the holidays.
Yeah.
Knocked the electricity off. It came back on, so it's back on, but we didn't know with people being gone and stuff, what apartments, what refrigerators were off, that sort of
Right.
thing, what food was gonna rot for 2 weeks or whatever. Is that considered an emergency? Can you go in and?
I would probably consider that emergency if people were out. I'd try to call them, to get contact with them, to be like, look, this thing happened, we're gonna go in, just to give them advance notice. But if you couldn't reach somebody, I'd say in that circumstance, yeah.
We have 300
Yeah.
units.
Yeah.
Does anything change with the process or the length if the tenants are Section 8 or if the tenants have minors?
So minors, no. Section 8, yes, only in terms of you have some additional requirements at the notice phase, and also when you're starting the case, you have additional parties you have to notify of that. But the process is exactly the same. And the reasons you can evict are exactly the same. So it kind of, but not really in the grand scheme of things. Yeah.
Back to security deposits?
Yes.
Is there anything written that states that security deposits can go towards unpaid rents?
Yeah, the statute
That's-
says,
okay.
right, so deposits can be withheld for unpaid rent, unpaid utilities, or other charges the tenant's responsible for under the lease, damage beyond normal wear and tear, and the removal and disposal of any personal property left behind.
But there's a notification paper document that you need to
You,
fill out.
right, you need to let them know within 14 days of what's happening with that deposit.
And then they have a certain amount of time to respond to you, right?
So if your property's in Burlington, they have a certain amount of time to file a claim with the Housing Board of Review if they're contesting.
And there was something where we had to wait, I thought, on the form, no?
No, Burlington's the only one that requires notifying the tenants that they have the right to bring the case before the Housing Board of Review.
What's appropriate notice for the 48 hours access?
You could do email, you could do text, you could do a phone call, you could do a phone message. There's no requirement the tenant receive the notice. It's like one of the
Well,
weirdest.
that's what I'm getting at. So you tell them?
Yeah.
You have evidence that you told them?
Yep.
I thought,
And-
I thought email wasn't considered.
For access,
Yeah.
it's fine.
Oh, it is?
Yep.
Okay.
Email's fine for access.
So even if they never respond, you
Correct.
show up and they.
Yep.
It's good to have it in writing.
Yeah, I think it's good to have it in writing. I think if you have a situation where you already know the relationship's maybe a little combative or tenuous, that do it in writing. Take a copy of the email with you when you go. So if like the police are called, you have a way to be like, look, I gave them notice in writing. Like this is their email address. You know, it's not sort of, you know, if they don't check their email, it's not your fault.
Two quick ones, just the 14-day notice, but you have someone leaving before the end of the lease, and they're still on the hook for the rent. You just need to notify them that it'll be updated at the end or when
Yeah.
it's rented.
Yeah, you can use
That's sufficient for
you
the
can use
notice?
estimates on the security deposit notice
Okay.
for both physical damages and for things like unpaid rent. Yep.
And then you had two reasons. Is there a third reason that you could get access or possession back during this process in a scenario where the tenant emails you or gives you something that says, I've vacated the unit?
Yeah, if the tenant is giving you notice that they vacated and you go over there and it looks like they've moved, then yes, you can take possession. Sometimes it's not as clear cut, right? Because tenants always move everything out and leave it broom clean, right? No. Sometimes
So
we
you're
don't
able to
know.
remove the items if they've given you that notice though?
Maybe. I mean, those are conversations that you would probably want to have with your attorney just to say, look, this is what I'm seeing, because there's a lot more going on potentially. So it's hard to give, sometimes with these, it's hard to give like, yeah, you can always do that, because maybe you can't. There are scenarios when you wouldn't be able to.
Even when they've said
Yep.
vacated?
Yep.
Okay.
Yep.
What about things that are in the lease? If you have an apartment that's in pristine condition and it's in your lease saying upon moving out, you will leave this apartment in exactly the same condition in which you moved in.
Yep.
And then when you do the walkthrough and it's not in the same condition and you tell your tenant, well, this is what the lease says, you didn't fulfill the lease, so, you
Isn't
know,
there a
if I
certain-
have to come and have professional cleaners come in, then that's gonna come out of your lease.
Potentially that stuff you could deduct out of the deposit. Yep.
How about normal wear and tear has to be taken into consideration?
It does. You know, we have a really big gray area right now regarding cleaning fees. And it's not, I don't have a good answer for folks. I have leases, or I've seen leases that are as specific as you will be charged $25 if I have to clean the refrigerator. I will, you know, you'll be charged this, you know, that are lists of this, and we're both agreeing that this can be deducted from the deposit if we have to clean these things. I've seen sometimes those get upheld, and I've seen sometimes them not get upheld. Don't have a clear-cut answer for where things are falling. Some of it depends on where the tenant takes the case or the issue. Housing Board of Review, you're probably not going to get it. small claims court or in civil court, you're more likely to get those charges.
If I have actual buyers and sellers, not landlords and tenants, and the buyer wants to move in early, or the seller wants to, a holdover, and we're putting in the agreements these days, this does not create a tenancy pursuant to 9 VSA, blah, blah, blah.
Yep.
Does that hold water?
Probably because there's an actual exemption in Title IX, the landlord-tenant statute, that says if you're occupying pursuant to a purchase and sale contract. So it's good to re-parrot that in the, the difficulty is going to be to enforce a move out. It's still an eviction, right? It's not necessarily a landlord-tenant Title IX eviction, but it's still an eviction. Because the only way to force somebody out the door that's not going willingly is to go to court.
So you're still going to have to do
You're still going to have to do an eviction. You just maybe wouldn't have to send them notice first. So, Erica, do you have another question? And then we'll go in the back.
As a city council candidate and potential city councilor, is there something that, and this may be an offline conversation where you can detail me, is there something I would actually be able to do at the city council level to influence some of this really sort of outlandish, over-the-top regulation?
Some of this, no. I mean, for Burlington specific stuff, so Burlington has its own little subset of ordinances that are different from some of the state. Most of what I've been talking about today is state driven. But there are things, but a lot of it's at the bigger state level. And some of it is just judge by judge. I mean, I travel the state doing evictions. I'm in every county in the state in front of 14 different judges, and they all handle these cases differently. Their clerks handle them differently. The sheriff's department handles them differently. I would love to get to the point where we have this consistent approach, but it's just humans are humans, and they all do things a little bit different. So you get a question in the back?
Yeah, just had a quick question for what constitutes service by the sheriff. Like if there's a 14-day window that something has to be served and the tenant is not there.
Yep.
And continues not to,
Yep.
goes away for a week to avoid it.
Yeah.
Because they know it's coming. What do
Yep.
you do? What constitutes the service by the
Right.
sheriff?
So usually it's in hand. So the sheriff has to physically hand it to them or attempt to hand it in them. I had a tenant once that the sheriff was handing them papers and he goes, nah, not taking it, la, 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 la. And the sheriff was like, nope, you've been served. So, some of it's the sheriff. But if they're avoiding service, there is a procedure where we can ask the court to issue an order saying we can just tack that paperwork to the door. But again, it's process, and you have to ask for it from the court. And the sheriff in this county has to make 10-ish attempts to serve before sometimes if they have a history with a person, we can speed that process up a little bit and fun stuff goes in the sheriff's affidavit. But so it kind of just depends. But generally we're looking 8 to 10 attempts before we can even get that affidavit. So they really make them work for it. Yep.
Does that count in the 14 days or does that extend the 14 days?
It's going to extend the 14 days generally. I mean, it's going to extend that hearing. Yeah. Again, that's that part of that delay, things that can be done to delay this process.
Now, just overall hearing everything, and things are done by state, then by county, in some towns. It sounds like a lot of the majority of the delay comes with the systems not aligning with each other.
Sometimes, yeah.
That's
Sometimes.
why it takes so long.
And some of it's just scheduling. Right? Some of it's scheduling. We really are at a point here where, at least in Chittenden County, we probably could have, there's enough going on at the court, 2 judges sitting in civil court. We have 1. They tend to look a little bit like the president from the start of the term to the end of the term when they rotate out after 2 years, because it's so busy up there. It's all budgeting and money. And the judiciary is always struggling with not having enough money and trying to cobble stuff together. I think we're still short on judges. We don't have the proper number of judges. In this county, we're not impacted, but in other counties, I don't have full-time judges sitting in civil court. I have, in some counties, like 1 day a month where they're handling the civil docket, or maybe 2 days a month they're handling the civil docket. So it's a systemic problem. So I'm going to take one more question, and then we got to cut everybody off because we're trying to be mindful of people's time.
So this has been great, thank you.
Yes.
It shows the entire process, and someone touched on it earlier, but I want to be more specific. Do you ever recommend, or have you heard of cash for keys?
Yes.
And then have them get out and say, here's your deposit back?
Yes.
Change the lock. Do you recommend that? Seems like a faster approach if they go.
It's entirely a business decision and a comfort level on the landlord.
What's that, paying them to leave?
Yes.
Yeah.
So the question was about cash for keys. I have some landlords who, on the principle of the matter, absolutely refuse no matter what, because they take the viewpoint that they're training tenants to have that expectation and rewarding bad behavior.
Yeah, but an
I-
eviction process can cost more than.
Yep.
I think it depends on the situation.
I think a lot of times it's situational. I have landlords who view it as a business expense. And if they know it's going to take X number of months and X number of dollars approximately to evict that tenant, and they can pay the tenant half of that or a portion of that, and the tenant agrees to it, they're in a better spot.
Do you need that in writing? I mean, what if the tenant comes back at you and says, they just kicked me out and this wasn't, I mean.
Well, you don't pay them till they leave. You don't pay them till they leave. And yeah. And I mean, I've had landlords that have knocked on the door with $10, $100 bills and said, if you're out by Friday, this is yours. And the tenant told them to where they could put that $10, $100 bills. So they won't all bite on it. Can you do it legally? Absolutely. Absolutely. Some people just won't, for the principle of the matter.
I don't have a question.
Oh, okay.
But
Is time up?
I don't have enough time.
Yes.
What I really wanted you to do is just talk for a minute about the Vermont Landlords Association and the advantages to landlords being.
Actually, let's just cut this off really early. How many of you are already members of the Landlords Association? Okay, substantial majority of you. If you are not, I have brochures up here. We advocate for landlords and help them out up to the court process, so it's a good resource for folks. We're one of the few organizations that's actually advocating for landlords at the state level, down at the legislature. Leases, yeah, rental applications. I saw a lot of hands up here, so I think most folks are tied into the organization. So, but thank you everybody for coming.